I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Department of Justice just notified the Special Master in the Mar-a-Lago search warrant Donald Trump's stolen documents matter. The Department of Justice notified the Special Master Judge Raymond Dearie that the parties resolved all of their disputes regarding attorney-client privilege, in essence, that none of these documents that Donald Trump was claiming attorney-client privilege actually were attorney-client privilege. Donald Trump is still making baseless assertions regarding these documents that executive privilege and that the records are personal records and therefore he should have it back, but he's dropped the attorney-client privilege claim. Let's pull up this letter from the Department of Justice to Judge Raymond Dearie. It states, "Dear Judge Dearie, plaintiff and the government's privilege review team, collectively the parties have resolved all outstanding attorney-client privilege disputes with respect to the materials segregated by the privilege review team, the filter team. Specifically, in the interest of efficiently resolving such issues and avoiding unnecessary litigation, the parties offer the following. Plaintiff, in this case Trump is the plaintiff, withdraws his initial claims of attorney-client privilege and attorney work product doctrine with respect to the following filter A and C materials, referred to by document number and base names as set forth in the October 3rd, 2022 dispute log." And it goes through all of the documents, and then in a footnote, the Department of Justice says plaintiff previously did not assert attorney-client privilege or attorney work product with respect to the other documents. And then it goes on to say, the parties agree that these materials can be provided immediately to the government's case team so that the issues concerning executive privilege and the Presidential Records Act can be resolved. And this is where my commentary comes in. There is no issues there. There's no executive privilege. There's no Presidential Records Act issue. If there was a Presidential Records Act issue, that gets filed in the District Court of Washington, D.C., which is the only court that has jurisdiction over Presidential Record Acts dispute. And the Presidential Records Act doesn't apply here because Donald Trump literally stole the documents that don't belong to him. You can't steal the documents and then claim records are personal and invoke the Presidential Records Act when you engage in the underlying criminal conduct at issues here, violation of the Espionage Act, obstruction and concealment, and mutilation of records. One other point the Department of Justice makes in this letter to Judge Raymond Dearie, they state, the government through its privilege review team agrees to handle document 17 and document 18 in the same manner as the filter B materials, namely the privilege review team will return the originals to plaintiff but maintain a control copy. So they're going to basically make a photocopy of it and keep it anyway, but they'll return the documents. And when you look at what those documents are, because the district court judge, Judge Eileen Cannon's court, made a mistake and accidentally unsealed what were the Exhibit A records, and we look at what Exhibit 17 and 18 were. 17 is printed email dated 12/31/2020 from Kurt Hilbert to White House email account regarding signed verifications for Fulton County lawsuit and federal complaint, and 3 verifications. This sounds awfully familiar. Didn't Judge Carter recently, a federal judge in California, just state that Donald Trump had signed false verifications in connections with lawsuits in Georgia? And let's look at Exhibit 18. From this Exhibit A list that was accidentally revealed by the district court back in late September or September, but this list was filed on August 30th. Printed email dated 12/31/2020 from Kurt Hilbert to the White House email account, sharing 10 files regarding the federal lawsuit. And so the Department of Justice doesn't care returning these emails. They have a copy of the emails, and why in the world Trump and his lawyers, if they have the email, would want the printed copy of the email? Like, literally makes no sense. But the Department of Justice will have those records, and undoubtedly we now know the new import potentially of these verifications that Donald Trump, at least in the case of what a federal district court judge in California said is filing false verifications. So when we're talking about what are these Exhibit A and Exhibit B filter documents and Exhibit C documents, I've talked about this procedure before. When the August 8th search warrant was executed by the Department of Justice, when they got Judge Reinhart, the magistrate judge, to sign off on the search warrant, the magistrate judge found probable cause. What you do in these circumstances is first, before the case team is the team that's investigating the criminal conduct at issue. Before they go in, the filter team goes in, which is a separate group of FBI agents and DOJ employees. They go in first and they look for any records in the same place the case team is going to search. But the first team, the filter team, looks to see if there's any potential documents that are attorney-client privileged, because they don't want to contaminate or taint the underlying criminal documents by allowing the case team investigating the criminal conduct from seeing potentially attorney-client privileged documents that they may not be allowed to see if there's a valid attorney-client objection that exists. So a filter team comes in, and there wasn't a whole lot of documents. I think this whole list, if you go back to the Exhibit A that I just showed up, we're talking about 21 documents, and Exhibit B may have been slightly more, 30 or 40 documents. And with the Exhibit B documents, those were like settlement agreements and just other records that had nothing to do with any of this. And the Department of Justice said as early as August, look, let's just return these records to Donald Trump. We'll agree to, return them and for you to have it back as late as early as August 30th of 2022. So Donald Trump, though, was making these frivolous attorney-client privilege objections, and also regarding the remaining documents, and also is still asserting executive privilege and something under the Presidential Records Act. He's claiming they're both personal and executive privilege at the same time, which, as I've talked about on prior videos, is completely inconsistent, because how could a record be executive privilege, meaning it is a confidential communication by a president, and also be a personal record, which is by its very nature not a presidential record. So it's internally inconsistent. But here, what the Department of Justice has now done strategically is, because the attorney-client privilege issues have been resolved historically, essentially in all cases, other than this one, because Judge Eileen Cannon, the district court judge who was appointed by Trump, has been completely off base, has been completely not following the law, and has done whatever Donald Trump's done. She's submitted a special master, this process of reviewing executive privilege and Presidential Record Act stuff, when the special master doesn't have jurisdiction, and the district court judge in Florida doesn't have jurisdiction over Presidential Records Act disputes. That's the Washington, D.C. District Court is the only place under the Presidential Records Act that has that. And then the special master should not be looking at executive privilege documents, because even Judge Raymond Dearie has said, where's the beef? What am I even here for? If there's no attorney-client privilege disputes, you're claiming that they're executive privilege against the executive branch. The law doesn't allow for someone to steal documents and then be a past administration, past president, and then say, I'm asserting the executive privilege over the actual executive branch under the current executive branch. You can't assert the privilege over the existing executive branch. This is what the Department of Justice has previously argued in its filings to Judge Raymond Dearie, and Judge Raymond Dearie gets it. And then the Department of Justice says these can't be personal records. These are government records. Like documents, if you go back to that Exhibit A list, even though Trump's withdrawn the attorney-client privilege records, like these documents are about like immigration initiatives and clemency requests and emails between a head baseball coach at the U.S. Air Force Academy and the White House. As the Department of Justice claims, these are obviously government records. These records don't belong to him. And so what the Department of Justice has done in narrowing these issues, and this is why they did it in this order, let's address the attorney-client privilege. Okay, there's no more disputes about attorney-client privilege, so the final dispute that's at issue now is you as a former president are claiming executive privilege over the existing president. Your whole argument, Trump, is that you could steal these these records and then just claim that you have a privilege over our actual government when you're not in government. So really, Trump now has to argue, the only thing he has left to argue, no more attorney-client privilege, is just completely against the law, and in fact further incriminating, because the more Donald Trump claims these records are his that don't belong to him, it shows that he stole the records. It shows that he's claiming property that doesn't belong to him. It's like the bank robber claiming that the money that they stole is theirs because by fiat, that they could steal whatever they want. So one thing I want to mention as well is here, this dispute so far in front of the special master has just been about, maybe these 50 or so Exhibit A and B filter team documents. One of the things the special master, Judge Raymond Dearie, is completely, just for lack of better words, lost patience about or is pissed off about is he hasn't even seen the disputes related to the 11,000 other documents. Now, obviously, all the attorney-client privilege stuff has been resolved now, although who knows what Trump may claim if he's claimed some of these other documents are. But the letter makes clear that all the attorney-client privilege records are resolved. So here you have another 11,000 other documents that Donald Trump stole. That doesn't include the 100 classified records, which are now out of the process because the 11th Circuit Court of Appeals granted the Department of Justice's motion for partial stay and returned the 100 classified, these top secret, sensitive, compartmented records. But Trump stole about 11,000 other documents, about potentially 200,000 other pages. Those have been uploaded through the e-discovery vendor in a process where ostensibly, if Trump is claiming all this executive privilege and personal records, these conflicting claims regarding this small set of like 20 documents, perhaps 15 documents or so. Think about what he's going to claim for the other 11,000 records. And earlier last week, Judge Raymond Dearie's like, where's the beef? I've had enough of this. I don't have patience for this ridiculousness in my courtroom. Just enough of this. Judge Raymond Dearie has just had it with Trump's lawyers. And so we'll see what Trump does with respect to those 11,000 other documents. But ultimately, where is this process headed? The 11th Circuit Court of Appeals granted the Department of Justice's motion for an expedited appeal. The briefing of the overall appeal, where the Department of Justice is saying that Judge Eileen Cannon should never have asserted equitable jurisdiction and got involved in the case at all. The Department of Justice is saying, look, this case should have stayed with the magistrate, Judge Reinhardt. Judge Eileen Cannon should never have granted Trump's motion for judicial oversight on September 5th. This was an unprecedented order of a judge hamstringing the Department of Justice from engaging in a criminal investigation using its own executive branch documents and allowing someone like Trump to steal it and block an investigation from taking place. And what the Department of Justice has argued to the 11th Circuit is, look, you've conducted the exact same analysis regarding the 100 classified records, regarding whether or not Judge Eileen Cannon should have asserted equitable jurisdiction over those classified records, and you found that she didn't. You found that the Department of Justice did not engage in a callous disregard for Donald Trump's rights. And if a district court judge doesn't make that finding, there's no equitable jurisdiction. You can't assert it. The other elements, the 11th Circuit, you've also found in our favor. There's no irreparable harm, and there's no need for Trump to have these records such that a district court should intervene when they are not by law supposed to intervene, because the bank robber can't have irreparable harm and a need for things back that they stole and it doesn't belong to them. And 11th Circuit, you return the 100 classified records to us. That same analysis that I just did applies to the remaining 11,000 other documents, and this whole process with the special master should end. Judge Eileen Cannon should never have done it. I think Judge Raymond Dearie, the special master, is going to be incredibly happy about this process ending. Judge Raymond Dearie was the former chief judge of the Eastern District of New York. He's sitting on senior status, a well-respected judge who's made appropriate recommendations that Judge Eileen Cannon's overruled. Judge Raymond Dearie sees all of the BS. He doesn't have time for the BS. And I think he's just waiting, and he realizes also that the 11th Circuit's likely going to remove Judge Judge Eileen Cannon from this process. And I think that's going to happen. Well, briefing concludes November 17th, and I think we will see a ruling by the 11th Circuit Court of Appeals, certainly before the end of the year, in my opinion, but likely, my guess is sometime after depends when oral argument is. So if they set oral argument later, that would change my analysis. But I think we see a ruling by them sometime early December would be my best prediction. But we will keep you updated here on all of the developments. But in summary, no more attorney-client privilege objections from Trump. So, and by the way, that is all special masters are usually supposed to hear. So when you look at precedent of special masters, whether it's the Michael Cohen case or the Rudy Giuliani case, these are cases where law firms have search warrants executed on them. Attorney-client privilege is an issue. There's lots of client material, and the belief is that a filter team, like the Department of Justice's filter retain team, that they can't do. It's just too complicated for them to sort that out themselves because there's lots of other client files and everything could be attorney-client privilege. So how do you really sort that out? Bring in a special master to do it. Special masters don't oversee executive privilege. Special masters don't deal with Public Records Act. There's a process for the Public Records, the PRA, the Presidential Records Act. And that process is through the DC Circuit, the PRA. That's the way that process works. So, anyway, we'll keep you posted with more information here on the MeidasTouch Network. I'm Ben Meiselas. Make sure you hit the subscribe button right now. Again, all disputes regarding attorney-client privilege are resolved. We're just dealing with executive privilege and Presidential Records Act stuff. So it's all teed up for Trump to lose. Hit the subscribe button. We're on our way to 1 million subscribers. With your support, in addition, if you want to help grow this independent media platform, go check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. A number of great exclusive content and exclusive content tiers there. Join them. Most importantly, it'll help grow this independent media platform. All of our competitors are funded by billions of dollars. We don't have that. We rely on you. So if you want to help out, that's one way you can help out in addition to sharing these videos. Patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.